Thank you. Thank you, honorable members. May I first check on the members of the portfolio committee? If they could just show their faces. Honorable Mkalipi, I can see we are here.
Morning, Chair.
Morning. Could I have the other members just to Honorable Taiposh?
Chairperson, good morning, members.
Honorable Van Veek, Honorable Mtolo. I think that's who we have for this morning. May I therefore request that we note there are members who have asked for us to be excused, who have apologized from the portfolio committee. This meeting is a meeting of the portfolio committee on COCTA, which is convened with religious leaders, as I think are represented here today.
Excuse me,
May
Chair.
I therefore take this opportunity to welcome all the members of the various religious organizations who are present here today. We will request that Sherin, the secretary of the committee, just to flight the list so we can see who is here. We may also, it's linked to the agenda, but I'll explain in a moment how we're going to deal with it.
Excuse me, Chair. I'm sorry to interrupt you. Steve Swatch, I just wanted to give note that I am here as a member and appreciate you allowing other members.
Member of what? Could you allow me to finish the introductory remarks and then I'll open up for comments?
Yes.
Yeah, I'll give you the space at that point. I'll give you the space at that point. I just do want us to deal with the preliminaries so that we can go into a much more structured and organized approach. So what we are here about are the issues that have been raised by various religious leaders, but I'd like you to look at the way that this agenda has been put, because I have actually asked that this must be changed. So if you can just move it up a bit, Sherin. You have a number of names that are showing. Maybe some of your names may not show. That might just be an error in terms of the list. But we will not follow a strict, rigid timing that you see on the side. What we will do, we have a number of leaders that are going to help to start the discussion based on the memorandum and letters that they've written to the committee. And then we will open up for members to follow. If your name appears, you might take the floor, but if not, you don't need to make any comment as such, because the matter would have been introduced, so it will be a general discussion. So I will not strictly then follow all the names as given, but I do want confirmation with the show of hands if people would like to speak, so that we don't force anyone to have to speak when in fact they would have been covered by a previous colleague from a similar organization. So I think the approach, therefore, I'd like to try and keep it as flexible as it would be. So for the honorable members of the committee, let me just ask if you want to raise any issues before we then get the religious leaders to comment on the approach. I do want us to try and tighten up the meeting so that by 11:30 we should try and be rounding up. If not, at the most it could go up to 12, but we really want to try and see if we can find each other in the process. Honorable Mkalipi.
Good morning, Chair. Good morning to the colleagues. Chair, I just want to check with you I also agree with your guidance, but maybe it will help us if you have an understanding the total number of the organization that have written to the secretary of the committee, and so we can know how many people are we expecting to come and do the presentation. Thanks, Chair.
Okay, there are a few organizations, I would say probably 3 organizations that have written as such, and one, I think, I'll get the correct names just now, but the rest of the members belong to the same organizations, but others may not be may not have sent the letters as such, but they would have raised the issues either in phone calls or in direct conversation, and that's how they got included to be invited. So, Shireen, can you just confirm that? Let's confirm that we have the numbers. What are the numbers we have? Then we'll come back to the Honorable Swart after that.
Chairperson, we received 6 formal letters from organizations. It was from the Freedom of Religion SA, from IDAMASA, from the Anti-Regulation of Religion Summit, from the South African Church Defenders, and then Pastor Zondi. Thank you, Chair.
Yes, I thought there were about 4 groups in all that got us to this point. And so the rest of the members would comment as we go along. We will not insist on everyone getting into the slot that they were given. So I would like members to have a problem with the fact that we didn't follow strictly what has been written here, because I did ask that we must change this approach. Now, let's can we get any other, sorry, how many people did you say we have today that are confirmed?
Chairperson, there is 16 organizations that confirmed that they'll be part of the meeting.
Is it 16?
16.
Okay, but the people, you'll have to count that. Okay.
Yeah, at the moment we have 53 participants on the platform.
Let's then get the other members. Any other comments from the members of the committee? Okay. What we'll do with the members of the committee, if in between there's a clarification that you need, you can raise your hands. We would like to take the submissions and listen to the conversation, and at the end, we will then come in and make comments as members of the committee if we wish to do that at the end. I do assume that we will understand this is not the first and it's not going to be the last meeting. There will be others that we're going to still engage on. So we may not necessarily conclude all the issues that we want to deal with. Can I then hold it at that? Let's get, yes, Honorable Taiposh. Honorable Taiposh.
Morning, Chair. Morning, Chair. Can you hear me?
Yes, I can hear you now.
Thank you. Sorry, Chair. I just wanted to ascertain something. We've got 53 participants in total, and okay, there's 16 groups that have confirmed. My question this morning is, obviously, there are people that is for the regulation, and there are people against the regulation. I just wanted to ascertain, because I don't think what we want is and I almost want to say, call it a fight in the meeting about who's for and why, and who's against and why not. So I just wanted to know if there's a common a goal in the meeting in terms of, is everybody against the regulation, or are there people that is for the regulation? Thank you. If people can indicate that, it'll just make it easier for us to understand their arguments.
Yes, I will give a full background to this matter, and then I'll deal with all those aspects as well. So we'll get to that point. I just wanted
All
us
right.
to
Thank you.
align the
Thank you,
approach
Chair.
first.
All right.
Yes.
Okay.
Okay.
Thanks.
Any other committee member? All right. Honorable Swart.
Morning, Chair, and morning to
Morning.
the members and to the guests. Firstly, let me apologize for interrupting you earlier. It wasn't my intention. I just wanted to, as a matter of courtesy, indicate that I am attending the meeting as a member of Parliament, and I just appreciate your allowance of other members from other portfolio committees. May I also just, if you allow me, just to mention a concern about the time given to each organization of 5 minutes. But I do appreciate that there are a lot of organizations and you've duly considered this. And you also indicated that this would be a first process of consultations. That having said, thank you very much, Chair.
Yes, I did. Thank you very much, Honorable Swart. As you know, members of Parliament are allowed to sit through any committee. And so your presence here is quite welcome. And also, you will also participate, like all the members, at the time when the parliamentarians are supposed to come in. So we do expect that we will all wait until that point. Then I want to, oh yes, I can see, of course, Subrathi there. Please come in. I see your hand is up.
Thank you, Chairperson. Thank you, Chairperson. Good morning to yourself and to honorable members. Chairperson, I'm not in the position to switch on my camera, if you can just indulge me. But mine is, like Honorable Swart, is to indicate that I'm not from the Portfolio Committee of Cooperative Governance, but I, like other MPs, have been approached by concerned religious leaders about this very important topic. So I appreciate the Portfolio Committee affording the opportunity to religious groups to express themselves. And as a member of Parliament, as you've indicated, I will stay on the call and I will participate as I see fit. Thank you so much, Chairperson, for this opportunity to convene this meeting and allow this platform to religious leaders to express themselves. Thank you so much.
You're welcome, Honorable Subrathi. So let me then say, at this point, I would like us to take you through a background. I will not ask members to introduce themselves. You will introduce yourself at the point when you are speaking. Honorable Swart is unhappy about the time slot. In fact, there will not be enough time ever to express all the views that there are on this matter. So I would like us to try and accommodate each other and cooperate as much as we can. The meeting has to be made to flow. So I would like you to just prioritize your issues in a manner that's going to make it possible that if we ask you to stop, you can then at least have covered some of the main issues that you would have liked us to focus on. It's not going to be possible to argue about time. Time is too short. Give me more time, Chairperson. We would consider that to be a bit problematic. I will ask that we try and keep to the time as much as we can. Again, I do want to request that let's allow the discretion of the chairperson in chairing a meeting of this nature, so that we do not have to be quibbling about points of order and I need more space and all of those issues. I think the discussion is a fairly important and very sensitive, and the leadership present here are very senior and very mature leaders. So the idea is to try and manage within the constraints of what we have amongst ourselves. Now, before I proceed, I do want to indicate to the meeting, there's a list of documents that were circulated. If there is any other that you might wish us to have sight of, please send it to Shirin. so that we can talk about it. But I will not be opening up space for a lengthy presentation at this point. I just want to take us through the background of the meeting so that we can then go into the discussion as it were. So the matter arises from a report from the Commission for Religious and Linguistic Communities, which is for short called CRL. And this matter goes back to 2017, 2018, 2019. Around that time, there were a number of issues that were worrying the society, South African society, in relation to conduct of certain leaders in various churches where there was consumption of rodents, congregants being made to consume rodents or snakes, or being fumigated or made to eat grass, and others where they were stopped from attending school, the children were not allowed to attend school, and a number of things that raised concerns. The CRL was then asked to look into the matter, which they did, and in the process, they ended up having to convene a discussion with various religious leaders about how to approach this matter. So we do have amongst the documents which we have amongst us a report which was tabled by the CRL to the Portfolio Committee on COGTA, and that goes back to, I think, 2018. Now, amongst these issues, if the members do have the report, it actually talks about a number of issues. Amongst them were recommendations that, having done the research, they felt that they needed to set up a committee, which is a Section 22 committee, which by law they are allowed to set a committee to assist them in doing some of the work. And in the course of the discussion, there was a disagreement that arose in terms of how to curb some of the excesses. The one side was everyone agreed that certain steps needed to be taken to deal with those excesses, but the manner in which this could be done is where there was a disagreement. In the first instance, others were saying we need to just utilize the existing legislation to deal with those problems. And out of the research, they indicated, the CRL indicated that there was a lot of reluctance and loopholes in implementing the existing legislations. And therefore, the proposal of a regulatory mechanism came about. And then a number of organizations that supported, and then a number also that did not support, and they felt that this process would infringe on the constitutional provision of the freedom of faith and religion. And therefore, they started raising the issues at that point. Now, a number of letters have been written to minister, to president, and to various leaders to object to this process. Now, this process was kind of interrupted by the fact that the matter was tabled by the committee to Parliament for adoption, but because of the end of term in 2018, the report had not been adopted by Parliament, so it does not stand as a resolution adopted by Parliament, and then it's lapsed at that point. Now, when the report lapsed, but nevertheless the CRL had continued with the committee, which is the Section 22 committee, and it was beginning to do some work. In the course of all of this, the members who had objected, that would include the FORSA, F-O-R-S-A, the freedom of religion, and then also the other one, the defenders, and others. I think at the end also, IDAMASA came in, and they raised a number of concerns, which were similar concerns that had been raised earlier on. And in that process, again, memorandum sent to the president, to the minister, and to the CRL process. Ultimately, a memorandum was sent to Parliament, to the Speaker of Parliament, and I was therefore requested to come and collect this memorandum in a march that took place in the front gates of Parliament, which was in November last year. I then accepted the memorandum, and then I promised that those who had raised the issue would be invited to come and address the portfolio committee at that time to deal with this matter. The portfolio committee had already had a briefing from the CRL, and the portfolio committee was preparing to have a meeting with the leadership that had objected to the Section 22 committee process. The committee invited the minister and CRL to come and discuss this issue, and the minister did indicate the limitations that the minister has over the role of the committee or on the commission, and indicated what they could and could not be able to do. And so the committee then wanted us to take the process forward. But in the meantime, then there was a court application that was moved by the members who had been objecting. And in the process, we were then stuck. We couldn't proceed with the meetings that we had offered to do with the leaders that had submitted the memorandum. Now, part of the reason why we couldn't proceed was that the court order had two issues with it. In the first instance, the court application had to do with the request of the CRL not to be engaged on a matter which was already in court, and that they would not be able to deal with the matter. We then had observed also in the application, court application, aspects that were or indicating that those who had gone to court had not seen the need for any mediation if you look at the papers. So the portfolio committee then felt that the issue that needed to be attended to was that we must get a legal opinion before we got ourselves entangled in this matter. The legal opinion is attached, or maybe will be sent to the members, so you will be able to have a look at the legal opinion. But in brief, it covered a few issues. The first issue we wanted to clarify was the status of the report of the portfolio committee to Parliament in the face of the lapsing period of the previous administration. And of course, the legal opinion indicated that the report was not adopted by Parliament, so it cannot stand as a report of Parliament. But two possibilities exist, and that is the current portfolio committee as a successor entitled who owns the work of the previous portfolio committee can either get the whip of Parliament to move that this matter be brought back from the previous report and be adopted by Parliament, which is one way of dealing with this matter. The other one is that the portfolio committee can look at all of the work that has been done and decide whether they would like to take the report forward in whatever manner. However, the portfolio committee needs to be aware that there is nothing they can't undo what has been done, except if they want to start a process that changes the direction in the way that they would have been dealing with it, whether it was them present or not, but it would be a matter of taking the step forward. In other words, we could either review what was decided or what was done before, but it cannot necessarily just be as a committee. We can't have a view that it didn't happen, or it doesn't exist. So we have to face the fact that there is a report in place, and that report we now need to move from that position. Then the other issue that was raised was that we were concerned about whether having a court application precludes Parliament from dealing with this matter. And of course, insofar as the court application is concerned, there is no, the Parliament is not cited, so we're therefore not party to the matter in court, number one. But secondly, on the issues that we were dealing with as Parliament, nothing stops the Parliament from engaging with anyone on the matter, which is why now we've then proceeded to have this meeting. Then the other aspects of it relate to the fact that what is the status or the legality of the Section 22 committee? It became clear as well that that was not set up as a resolution of a portfolio committee or a parliamentary process. It is on the basis of the mandate of the CRL. Therefore, it does not really get affected by where we are at this point. Then the question that as a committee we thought is the nub of the matter is that there is nothing illegal about the Section 22 committee. The issue is whether the approach to the Section 22 committee is indeed transgressing the constitutional provision, which is the freedom of religion and the rights of individuals to practice their faith in the way they understand and believe in it. And therefore, that we understood to be the nub of the issue that really takes the matter to court. So we then felt that to the extent to which, firstly, we have made an undertaking and we've been requested to engage with the leaders, we then owe the various leaders an opportunity to come and address the committee. That would be one. Secondly, we would want to engage with those stakeholders who are part of the conference, the consultative conference, so that those issues that were discussed, we must understand them better, as now we know that there were others who had supported the process of the Section 22, there were others who had not supported it, but also the question of whether there is interference with the constitutional rights of individuals to religion. It's a matter that I think is what causes the debate. So we want to leave it at that without going to any further. Our objectives of this meeting are twofold. One, we want to hear your views as you have raised them with us. Secondly, we would like to also hear what are your proposals of how this matter needs to be dealt with or can be resolved. Those would be at the end of it, the issues. We're aware that there's been a lot of debates and so on. I have left on the side the specific objections to the statements made by Mr. Mkhwana Zikaluva and the whole interpretation of what that means and all of that. I've left those because I believe that will be part of some of the issues that you will be raising. I'm also aware that the chairperson of the Section 22 committee, Professor Xulu, who was appointed at some point, also made a public statement and resigned out of that. And we might just get a bit of insight onto that because he is also amongst the people who are invited here. So I would like, therefore, that we open up the discussion and certainly let me then invite, sorry, Shireen, if you can just see so we don't create too much of confusion, you can just put the list back so we can identify the first few to give us the comments. Okay, so all right. So what we're gonna request is I'm going to change the order a little bit because I'd like that we start with Pastor Mukuba, who's from South African Church Defenders, then Mr. Michael Swain from Freedom of Religion, and then Dr. Shimi Kotu from Anti-Regulation of Religion Summit, and then I would like us to have Damasa. After that, we will then open up those who are on the list. If they still wish to speak, they can just raise their hands and we can acknowledge them as we go. But I would like us to take that order. Pastor Mukuba, Mr. Michael Swain, Dr. Shimi Kotu, and then Damasa. Then we will continue because those are the letters that we have received. But of course, many of you participated in the memorandum. Can I ask that we follow that approach for now? So, Pastor Mkuba. You are muted.
Can you hear me?
Now I can hear you.
Thank you. Thank you.
Thank you. Please proceed.
All right. Thank you very much. Thank you very much, Chairperson. And I would like to greet you and all honorable members of the Portfolio Committee and all the religious leaders on the platform. We thank the committee for the opportunity to make this submission. The South African Church Defenders appears before you, and it is pursuant to the memorandum delivered to the Speaker of Parliament on 13 November 2025, and in response to the committee's invitation to make representations on the conduct of the CRL Commission and its chairperson, Ms. Tokom Kwanazi Kaluva, particularly in relation to the current initiative described as self-regulation of religious institutions. We approach this matter with full respect for Parliament and with a clear appreciation of its seriousness. The issue before this committee is whether a Chapter 9 institution has exceeded its constitutional mandate, disregarded prior parliamentary findings, compromised its impartiality, and embarked on a predetermined process aimed at regulating religion in a manner inconsistent with the Constitution. At the outset, we must state it clearly, we do not reject accountability. The CRL is empowered to educate the public on what constitutes abuse and criminal conduct, and to work with competent institutions to ensure that perpetrators are brought to justice. Where a crime has been committed, the law must take its course. There is no such thing as a pastoral crime. A crime is a crime. The church cannot be made a scapegoat for systemic failures in law enforcement or regulatory capacity. Criminal conduct must be addressed through existing laws and institutions, not by creating parallel structures that target religion. The current initiative by the CRL is not new, as you have stated, Chairperson. Between 2017 and 2020, this committee considered and I believe did not really approve the regulation of religious institutions, including compulsory peer review. And after those public hearings that were done, Parliament did not recommend legislation, recognizing the serious constitutional risks such regulation would pose. As confirmed by the Speaker of Parliament, those findings have since lapsed and have no legal standing. Despite this, the CRL has returned with a substantively identical proposal now framed as self-regulation. The change in terminology does not alter the constitutional analysis. The CRL Section 22 Committee's own document contemplates structured oversight of churches, coordination through recognized bodies, and the production of a report recommending legislation to Parliament. Clause 2.3 of their document makes it clear that the process is rushed and outcome-driven. Consultation with a predetermined outcome is not genuine consultation. It violates the principle of legality and the constitutional requirement of meaningful public participation. The constitutional framework is clear. Section 15 guarantees freedom of religion, belief, and opinion. Section 31 protects the right of religious communities to practice their faith and maintain their institutions. Section 18 guarantees freedom of association, including the right not to be compelled into state-controlled structures. Chapter 9 institutions are bound by Section 181 to act independently, impartially, and without fear, favor, or prejudice. Against this backdrop, the conduct and public utterances of the CRL chairperson, Ms. Mkhwanazi are deeply troubling. In repeated public statements, she has asserted that churches must be regulated. She has suggested that individuals who claim to hear from God should be taken to psychiatric hospitals. She has mocked religious beliefs through references to angels underwear, and has spoken openly of dislodging and demystifying the power of pastors. We ask this committee plainly, who mandated her to do this? Certainly not the Constitution, certainly not Parliament. These utterances go beyond poor judgment. They demonstrate bias, intolerance, and hostility towards religion, and they undermine the neutrality required of a Chapter 9 or office bearer. Instead of promoting social cohesion, we see the chairperson having sown division, placed churches under intense and unnecessary pressure, and eroded public trust in the CRL as an independent and impartial institution. In this respect, the chairperson has failed to demonstrate her suitability and fitness to hold office. The establishment of the Section 22 committee must be viewed in this context. Serious concerns exist regarding its altered terms of reference, its selection criteria, and its representativity. There is legitimate doubt whether it reflects the diversity of Christianity in South Africa. The resignation of its chairperson, Professor Kulu, further undermines confidence in the process and raises serious questions about its legitimacy, stability, and integrity. It is therefore misleading to suggest that the CRL is merely implementing parliamentary recommendations. Parliament rejected the regulation of religion. There is no mandate to implement. Any renewed engagement would have required a fresh, neutral, and constitutionally compliant process. That has not occurred. Chairperson and honorable members, what is at stake are fundamental rights. Freedom of religion and freedom of association are foundational to South Africa's constitutional democracy. These rights cannot be limited at the discretion of a Chapter 9 institution or its leadership, but only in strict compliance with Section 36 of the Constitution. For these reasons, the South African Church Defenders submit that the CRL's regulation initiative is unlawful, unfair, irregular, and unnecessary. The conduct of the chairperson has compromised the integrity of the process and brought the institution into disrepute. We submit that she should be suspended or removed pending a full investigation, and that the Section 22 committee, now further weakened, should be disbanded. We do not oppose accountability. We oppose unconstitutional control. We do not resist engagement. We resist predetermined outcomes. We will lawfully, resolutely, and constitutionally protect our rights, our freedoms, and integrity of our faith communities. We respectfully urge this committee to exercise its oversight role decisively, to reject any attempt to regulate religion under the guise of self-regulation, and to affirm Parliament's commitment to protect religious freedom and the Republic of South Africa. And in conclusion, we thank the committee so much for its attention. Chairperson and honorable members, the churches of South Africa are not asking for immunity from the law. We are asking for equal treatment under the law. Crime must be dealt with by criminal justice institutions, not by regulating belief. Accountability must never become control. Oversight must never become hostility. We urge this committee to protect constitutional freedoms, restore confidence in the CRL, and ensure that no institution is permitted to place itself above the Constitution. Thank you very much, Chairperson.
Thank you. Your timing was perfect. Thank you, and you've set a good example. And thank you so much. Let me also say, for members who have something that's been submitted, that's in writing, feel free to send that to the secretary, whether you would have spoken or not. So we will accept that and look at all of it together. So as the members would have seen, the first few who are going to be doing the submissions have got 5 minutes, and then we will regulate the time to be less as we go further, because the bulk of the issues would have been tabled. Now, here in Parliament, 3 minutes is a very long time. 5 minutes is more than enough. So don't feel in any way constrained. I know the rules are different at the pulpit, but in Parliament, this covers the situation quite well. May I invite Freedom of Religion South Africa, Mr. Michael Swain? Same amount of time, 5 minutes.
Thank you, Honourable Chair. We really deeply appreciate the opportunity to address this committee and the honourable members this morning. I trust that you can hear me okay. Let me begin by saying...
Yes, please proceed. We can hear you well. Proceed.
Thank you, sir. 4SA Freedom of Religion South Africa is here because we are a constitutional legal advocacy organisation. That means that our existence is to uphold the constitutional right to religious freedom and the other related rights granted by the Constitution. It should be noted that we are faith and doctrine neutral. We are politically neutral. And we uphold these rights for people of all faiths, or for that matter, no faith at all. We are therefore not activists, and we are certainly not agitators. Our mandate is not theological and it's not political. We come from a purely legal perspective. Let me begin by saying something which has been said, but let's say it plainly and without qualification. Yes, there are abuses within the faith sector. Some are serious, some are criminal. Gender-based violence, financial exploitation. These things must be confronted directly, and religious leaders who commit such crimes must face prosecution like anyone else to the full extent of the law. But this is not an attempt to minimize harm. A crime is a crime, no matter who commits it, and religious freedom has never been an excuse or a defense in law. There is therefore no such thing as a spiritual crime. Crime is something that must be dealt with and enforced by the state against perpetrators, no matter who they are, without fear or favor. The issue for this committee, and you said it very well and eloquently, Chair, is not whether abuse exists. It is whether the proposed solution by the CRL and its Section 22 committee, namely legislative state regulation of religion through peer review mechanisms, is constitutionally justified, practically workable, or indeed necessary. And our respectful submission is that it is not. Now, Chair, you again eloquently set out the history of this, and I don't want to elaborate on that. The only thing that I did want to point out, of course, is that Parliament did not support the call for legislation. Instead, its resolution involved the religious sector pursuing self-regulatory measures within existing constitutional and legal frameworks. And that outcome was not incidental. It was, as you are aware, the product of engagement, deliberation, and oversight. And Parliament weighed the evidence and made a policy choice. So I think the key question today is a straightforward one. What has materially changed since 2018 to justify reopening a matter that Parliament, yourselves, the Cooperative Portfolio Committee, has already examined in depth and decided against? So if the underlying facts are essentially exactly the same, then obviously those proposing this legislation, the CRL in particular, need to demonstrate why it is necessary now. And if in the intervening years, the faith sector has in fact taken meaningful steps to strengthen accountability, and it has, then this argument obviously for coercive regulation becomes significantly weaker. So let's just, if we can for a moment, take note that since 2018, the faith sector has not been idle. One of the first initiatives that took place in response to Coop's recommendations in their 2018 report was indeed taken by senior leaders of diverse faith communities, and it commissioned the authors of the Religious Freedom Charter, Professor Rassie Malherbe is here today, to oversee an interactive process to develop a code of conduct. That was a specific recommendation, and this was developed by and for the faith communities. Now, this Religious Freedom Charter had already been adopted by 20 million people of faith and diverse faith backgrounds in 2010, including, incidentally, the CRL Rights Commission. And the agreement was that since the Freedom Charter was the commonly agreed exposition of the rights of religious freedom, it was the ideal baseline from which to develop a code of conduct to expound the corresponding responsibilities of those rights. And that, Chair, is obviously a big solution that is something that you asked us to present today. And this project was completed. And we believe that it is something which stands very tall when we're looking at alternative solutions. Another potential weakness that the COGTA 2018 committee presented was a sense that there were many independent churches and questions were raised about accountability. But again, it must be noted that in 2021, the South African Community of Faith-Based Fraternals and Federation, and the SACOF, who are also present here today, was formed. And this now represents...
You have 1 minute to finish off. Proceed.
Thank you, sir. I was actually asked by other people who are here present to take a little longer because of our extensive institutional background. If you could perhaps indulge me a little longer. But as I say, now 24,000 churches are under the SACOF banner. And we went, I say we, Freedom of Religion South Africa, SACOF, the United Ulama Council of South Africa, the Nkululeko Yazizwe Association of Traditional African Faith Fraternals, and met with the CRL in May last year. And we took with us solutions and we appealed for cooperative implementation. We expressed a willingness to strengthen accountability together that was not a confrontation. It was an offer of partnership. Unfortunately, that offer was not accepted. And instead, we have a situation which unfortunately is becoming increasingly adversarial. So the constitutional principles are at stake. Is that Parliament should not be asked to legislate where cooperative, less restrictive solutions that have not been genuinely pursued and exhausted have been presented. Section 36 obviously permits the limitation, but only according to the test in that particular section. And from a practical perspective, there is obviously significant laws that are in place and effective that regulate, let's say, abuse and bad behavior. So what are these practical considerations? Well, we believe that the main ones is that this committee should be now seeking clarity on whether such coercive legislation is indeed contemplated. It should also ensure that there is strict constitutional compliance with anything that is contemplated. And of course, to give fair and full consideration to non-legislative alternatives, and 4SA has submitted those as part of our proposal, which we believe will fundamentally address and deal with the issues. And again, we should be encouraging cooperative engagement rather than further polarization. And Chair, we do not need a struggle between the state and faith communities. What we need, we believe, is principled partnership within the constitutional boundaries. And obviously, the tragedy of abuse must never be minimized, but neither should it become the basis for constitutional overreach. So we respectfully ask this committee to uphold the constitutional equilibrium once again and protect citizens from harm while safeguarding the freedom that remains one of the cornerstones of our democracy. And we thank you for this opportunity. And our presentation has indeed been submitted to you together with our alternative solutions and a copy of the aforementioned Code of Conduct. I thank you, sir.
Thank you very much. That is very helpful. So we did give you a little bit of time because you started name dropping about who we might take the time from. So that's fine. Let's get to the next submission. Dr. Shimikotu from Anti-Regulation. Can we get Damasa to get closer because they will have to make the submission. I think Mr. Zondi, I think is the name. But proceed. In the meantime, we're not doing Zondi now. We're doing Kotu. Please proceed. You got 5 minutes as well.
Thanks, and the community for inviting us. The anti-regulation of religious standards shall not release the content in the
You have a bit of a challenge. Sorry. No, you have a challenge. Okay. From where I'm sitting, maybe you're a bit far from your mic. It's a bit muffled. Try that again.
How does it sound out, sir?
A bit closer again.
Yes, sir. Is it better?
It's better, but not quite where we want it.
Really?
Just try again. Proceed. Let's see.
Do you hear me clearly now?
Yeah, let's proceed. I think it's better.
Okay, sir. The anti-regulation of release in summits shall not reiterate the content of the CRL letter.
No. Cut off your video, and then just focus on the sound. It might improve a bit.
Okay,
You can switch off your video. It's fine because I think something is going wrong somewhere. If you brought your mic closer to you and just adjust your mirror, your camera a bit, sometimes we cut off the video if we think your sound is compromised. It helps, but if it doesn't, can I give you a bit of time to try and work on it? I'll get the next person to come in, and then I'll come back to you. Let's see if we can fix that. We still want to get your input. So I'll get the Damasa to come in whilst we're trying to fix your side, and then we'll come back to you. Mr. Zondi, you can come. You got 5 minutes as well.
Well, good morning. Good morning. Thank you very much, Chairperson. I'm Bishop Nati Zondi, speaking here as representing IDAMASA, Interdenominational African Ministers Association of Southern Africa. I would like to, let me also greet all the honorable members and my colleagues who are all here. And thank you for the opportunity. I'll definitely try and stick to my time. The IDAMASA, first and foremost, maybe would like to remind this committee, in as far as the chairperson did refer to the previous report, which you commented on. Just I want to highlight a few things on that report, which I think would be relevant for the discussion today. If you look at what the observations that were made by the previous COCTA committee, there are a few, but I'll highlight some. The first one was that the committee noted that the Commission did not do sufficient public participation in the previous exercise that the CRL keep referring to, because only 85 denominations were invited. The second one was that there was disagreement over the constitutionality of the recommendations of the CRL. And the third one was that religion should not be commercialized. The fourth one, denominations have been sufficiently regulated, and this has been working very well for them over a very long time. The last one, which I want to quote, is that commercialization is an infringement of the constitutional right of people. IDAMASA endorses those observations. And over and above that, in as far as the letter that we've submitted is concerned, we would like to highlight the following. It is in our view that the Commission currently continues to act beyond its constitutional and statutory mandate as it continues to pursue an agenda that will ultimately result in interfering in the internal affairs, governance, and doctrinal matters of churches and religious institutions. And in our view, this behavior is not in line with the Commission's role, which is to protect and promote the rights of religious communities. But instead, it continues to attempt to regulate and to control religious institutions and their practice of faith. The second point Chairperson would like to raise with this commission is about the Section 22 committee, especially in how, as you have noted, it was formed. In our view, this committee's formation was exclusionary. We noted with grave concern that in its formation, the CRL Rights Commission, instead of engaging all other Christian formation, handpicked a few. And in its composition, glaringly, it became unrepresentative and exclusionary because it omitted some of the formations such as Itamasa and various other African independent churches, and of course other charismatic and Pentecostal groupings. And this process and its criteria remains unclear till today on how it was done. So this exclusion, in our view, is deeply concerning because it denies equal participation to legitimate and long-established Christian institutions in shaping discussions that directly affect the broader body of Christ in South Africa. It also reflects the selective engagement by the CRL leadership, which appears to handpick participants aligned with its own perspective, while sidelining those they view as dissenting or they view as independent voices. In our view, this violates principles of fairness, inclusivity, and transparency as required of a Chapter 9 institution. And therefore, it undermines the integrity of the CRL Commission, especially in its work within the religious sector. So in our view, this community, and of the committee to be aware. As the first speaker has alluded to the public statements, we do raise our concern. We feel that these statements undermine Christian beliefs. They are troubling because what they do, they put to question the legitimacy of Christian spiritual practices such as hearing from God, healing, prophecy, deliverance, tithing, etc.
Please round up.
Now, these, in our view, Chairperson, cannot be left unattended because they also they erode the public confidence of a Chapter 9 institution. So our suggestion and our proposal, therefore, is that this committee should also do an investigation on the conduct and the decisions of the CRL Rights Commission's leadership, especially as it relates to the Section 22 committee. We propose that the operation of the Section 22 committee should be halted or suspended until an inclusive and representative process is undertaken, ensuring fair representation of all major Christian groupings and denominations. Thank you very much for the opportunity, Chairperson. This is our submission as Itamasa.
Thank you, Bishop Zondi from Itamasa. Let's come back to Sekotu. Let's see if you have cured your technical glitch. You are at this point muted. You're still muted.
Yes, sir. Good morning.
Proceed.
Do you hear me now, Chair?
Yes, I can hear you.
Thank you. The anti-regulation of religion. Okay, thank you, sir. The anti-regulation of religion summit shall not reiterate the content of the 3 letters we have already submitted to the portfolio committee regarding the operations of the CRS Commission. We have 5 basic recommendations and we have reasons for that. What we recommend as a way forward for the portfolio committee is as follows. We call for the immediate suspension of the Section 22 committee as it is unconstitutional in its establishment. It's not representative and is completely irrelevant. Why is this committee implementing the recommendations of an expired, elapsed, and non-existent report? But then, even if that report had any status before Parliament, Parliament had rejected the CRL's attempt at regulating religion on the basis of those recommendations being unnecessary, unconstitutional, and unworkable. Of particular concern to us are the following. We keep asking the CRL Commission to give us proof that since they're a Chapter 9 institution and 12 commissioners were appointed, and every reference to decisions taken by the CRL Commission is commission. And the fact that the chairperson has no executive powers, we have asked them to give us the resolutions that established the Section 22 committee. Ms. Kaluva makes a vague reference to a meeting of the 5th of February, 2025, where a resolution, a quasi-resolution was taken to establish this. But if you investigate that further, we want to see a plenary resolution that determined the committee's mandate, that determined its terms of reference, that determined who would serve in the committee, which determined a transparent recruitment of these committee members, and that determined how they would vet them. One of their members, the Section 22 members, CBC, blatantly came during the press conference last week and said, some of the members sitting here in the Section 22 committee come from those churches which groom young girls for marriage and which promote pedophilia. We have asked for those that piece of information, and it has not been forthcoming. So, if you consider Professor Kulu's presentation on the 15th of January, not only is the operation of this committee solely under the control of the chairperson, she keeps altering and amending the terms of reference at will, as and when she wants. She is confusing the definition of full-time commissioner with executive commissioner. Ms. Kaluva has no executive powers to make decisions on behalf of the committee. And one error, one blunder, is the formation of the Section 22. We are calling for its suspension pending the further investigation by the portfolio committee. The second thing we call for is the immediate precautionary suspension of Ms. Kaluva as a reckless modus operandi is detrimental to the CRL's mandate and its constitutional obligations, which is merely to protect and to promote religious rights. She is way beyond that. Her era as chairperson has turned the commission into a vigilante body. And in her referring specifically to her, she's a constitutional delinquent. She does so much to disregard what the Constitution said the CRL Commission should do. But then she is of the opinion that once you have legitimately identified a problem, how you resolve it does not matter. That's vigilantism. We agree that there were abuses. We agree that there was criminal activity. But there are constitutional ways, there are legal ways to resolve that. So we consider her a constitutional delinquent. And if you understand the concept of constitutional delinquency, it's behavior that contradicts the supremacy of the Constitution. Under her chairmanship, the CRL is failing to meet its constitutional obligation. The concept of a constitutional delinquent stems from the principle that any law or conduct inconsistent with the Constitution is invalid, and she epitomizes that. 3, we are calling for the formation of a parliamentary error committee to investigate all allegations brought to COGTA by the religious committee against Ms. Kaluva. 4thly, we are recommending for the invitation of the other 11 CRL commissioners. And it's important that we do so because, one, the president did not appoint one person. He appointed 12 people, and there are nowhere in the press conferences, there are no plenary resolutions. We think if Parliament sets up an investigative process and all the other 11 commissions are invited to make presentations, we may establish one of the two reasons. The first probability is they are complicit in the unlawful acts and irregularities perpetrated by their chairperson, or they are completely bullied by her and their appeals for intervention are ignored. Our last recommendation is a thorough investigation of allegations made by Professor Kulu. They were damning. In this media conference, he made references to allegations that are reminiscent of our conversations with the CRL commissions. Togo Kaluva thinks that the CRL commission is a personal entity, whereas according to the Act, she has only 3 responsibilities. She's supposed to convene plenary meetings, chair those meetings, and convene a national consultative conference, not to operate as a de facto executive chairperson of the CRL commission. We think the other commissioners should make presentations to Parliament to establish if they are complicit to what we see as this unconstitutional behavior, or maybe they've been bullied. I'm going to restrict my presentation to these 5 recommendations, and I pray that they meet your most favorable response. Thank you, Mr. Chair, and thanks to the committee.
Thank you very much, Mr. Kotu, and thanks for your submission. And I do know you did submit some of the issues earlier, but if there's anything additional, you are free to submit.
Thank you, Chair.
Thank you. We have taken the first 4 of the bodies that were primarily at the beginning of the concern raised. Now, I will be asking for additional comments now from the other members, and I would like you to, if you can just show the show of hands, those who might wish to be considered. At the moment, I have 4. I'm going to hold, well, it's 5. I'm going to hold onto that. Seeing that we have had a lot submitted before, and some of you were quoted as a reason why it had to be a bit longer, I'm going to ask you to restrict yourself to now 3 minutes. And I'm going to go by the order of raising of the hands, and assuming that those who might appear on the list, and if they wish to speak, they will indicate when they are ready. And if not, we will not insist that your name is on the list. We'll insist that your hand was up, and then we will take you from there. So if we can just cooperate that way, and we can then take the order in the following manner. We'll take the names in the following manner. Firstly, we've got Marcus Manar Al-Fikr. My pronunciation may not be that good. My apologies. And we've got Pretorius. And we've got Christoph Sauer. And we've got Stephen Swart. We've got Ras Malherbe. But can I ask, before we do that, can I just deal with the Honorable Member Mkalipi? I will always do this just so that we can guide each other on the meeting. Before we can get to the member, Honorable Mkalipi, your hand is up.
Yes, Chair. No, I just wondered, because we are listening with interest, and it's very interesting, if we can also ask the leaders who are making presentation to come with recommendations, because so far, all of them, or if not all of them, I might be as well wrong, they are sticking to say that the chair of the commission must be suspended. But we really, really want to hear from them the recommendation to solve this problem that we are facing with. Thanks, Chair.
Thank you very much. There have been some suggestions that we have picked up.
Recording in progress.
Hope we can consolidate them as we move on. That will come out in the report. I won't go into that now, but your point is noted. Can we just ask the members to focus on solutions as well, proposals of what can be done. So let's follow the order. Markaz Manar Al-Fikr will be the first. And 3 minutes is maximum. It's not compulsory. It's maximum. Please proceed.
Thank you very much, Chair. And good day, and good day to all the members. So basically, I'll be speaking on behalf of the Muslim community, and we'll be representing a wide range of organizations, which include the United Ulama Council and all its partners, as well as the Muslim Lawyers Association. And we just want to firstly place on record that we agree with the other presentations, particularly FOSA and the other members, about the core issues that we're currently facing. Basically, that any move towards any type of regulation of religion is a threat to religious freedom in South Africa. And I know many of the key points have already been mentioned, and these are
points that we as a Muslim community also find very concerning. And for the benefit of all those present, I'll try to keep my presentation as short as possible. So I just want to actually focus on one concern that we have as the Muslim community, and that is that the process that began was totally unfair, and we believe it was unconstitutional because we were excluded from the entire process. And Chairperson and other members, what we want to be very clear is that we not support the CRL Rights Commission Section 22 approach. And what I'm about to say is in no way we're trying to endorse it. But our concern is that when this process was initiated, it effectively started with one faith sector, which is the Christian sector, while the other faith communities were not included from the onset. And this, according to us, is not any small procedural issue. It's actually a serious concern to us, because our concern is that if a process that can affect all faith communities begin by excluding other faith sectors, then it is not meaningful consultation, and it creates a strong impression that the direction is being set first, and then other religions will basically be invited later to just simply comment. In other words, what we're basically saying is that the entire procedure is unfair, and we're being marginalized as other faith communities, which includes the Muslim communities and other communities. Because basically our concern is this, that once the discussion with the Christian faith is complete, then we'll already have a set of norms, expectations, and enforcement ideas that can directly affect all the other communities. And we are basically being excluded from that entire process. So that's why from the onset, we have on several occasions requested to be part of the process, and the CRL chair, dismissed this concern. She said each religion should be treated individually because we don't want to mix the matter up. But our concern is this, that as long as you start one at a time, you're already going to create norms, you're going to create standards that will inevitably affect all of us. And I just want to touch now on the final point that was mentioned about...
You have done your 3 minutes.
Okay, thank you very much.
Yeah, thank you very much. Let's have the next speaker, Mr. Jan Pretorius.
Thank you, Honourable Chairperson, Dr. Mkhize, and also the Honourable members and colleagues. This is our statement to the PC Committee, the Portfolio Committee at COPTA. Thank you for the opportunity for us to address this committee. We are standing again also on all the previous statements, and we wish to just highlight a few things from South African community of faith-based fraternals. We stand here today representing them, and SACOF today compromises of about 239 member bodies, fraternals and federations with close to 21,000 faith organizations. It's churches, networks and federations and denominations. And over the past few years, we have seen a growing number of previously unrelated and independent churches voluntarily associating themselves with recognized umbrella bodies like SACOF and many of the others that are here. And this trend is significant. And I think it does demonstrate that the faith sector is not resisting accountability. Rather, it's actively seeking structured, peer-based accountability within the constitutional compliant framework. And within us, we as the faith community know exactly that there is a big problem, and we are actively working against these fraudsters and criminals that do hide under the banner of faith. But however, our engagements with the CRL Rights Commission under the leadership of Ms. Toko Mkonazi-Taluva has been deeply concerning. And personally for us and a few of our member organizations, we have been excluded critically from critical engagement affecting the religious sector. And on certain occasions, it was through administrative processes and in certain engagements, even physically, where there was security that we couldn't even be included. It wasn't incidental. It is. It appears deliberate. And as some of my colleagues before me said, that it looks like it's a cherry-picked grouping. Now, what I want to get to is that SACOF, together with all other partners that are on here, have submitted comprehensive alternative recommendations to the CRL, constructive solutions with our personal one-on-one meetings with them. But these have been ignored, and these recommendations were practical, legally grounded, and sector informed. So a few of these are existing legislation and non-legislative options and alternatives to strengthening those, having charters and codes that we all assign to voluntarily, having these groupings, umbrella bodies that keep our members accountable. But our concern is that all these alternatives have been unreasonably dismissed without proper consideration. To end off with, Chair, to try and keep within my 3 minutes, we want to just make sure that we also, furthermore, out of the mouth of Professor Tulu, these concerns have been corroborated, and certain of the statements that we've made before his resignation was just corroborated, and we want to make sure that we have an inclusive. Thank you, Honourable Chairperson and members. We would like to just ask for fairness and constitutional integrity. Thank you, Chair.
Thank you very much. May we have Mr. Christoph Sauer?
Honourable Chairperson, thank you for the opportunity. I present on behalf of the International Institute for Religious Freedom and its South African branch. As a professor of religious studies and expert on religious freedom, I'm a long-term observer of the matter under discussion. And basically, I concur with the preceding speakers. Let me point to issues that have not been mentioned yet. 5 recommendations. Number 1, take into account the purpose for which CRL was created. Query what aspects of the CRL's current interventions regarding religious communities are covered by that mandate and which are not. If necessary, ask those who helped create the CRL. Number 2, take into account the complete history of the CRL's involvement with proposed registration and regulation of religion as a response to various abuses and irregularities. I covered this in an essay on safeguarding freedom of religion or belief, assessing the recommendations of the CRL Rights Commission in light of international human rights standards, that is available open access. It covers the previous term of office of the current chairperson until 2019. Unfortunately, the balance of the record is quite negative, and I see an extension of this mode of operation in the current term. Number 3, take into account the whole history of COCTA PC's involvement with these issues. If you decide to revive the lapsed COCTA PC's recommendations of 2018, may I recommend that you equally consider the outcomes of COCTA PC's Indaba with religious communities on harmful religious practices, conducted 10 to 11 March 2020. The then acting COCTA PC's chairperson had commissioned me to summarize the suggestions made to deliberate on the way forward. These were tabled and discussed, and the COCTA PC was to decide on them thereafter, but then came a pandemic and lockdown. These suggestions contain 14 points, among others, recognition of alternative solutions and acknowledging that the religious communities are doing a lot for self-regulation, as has been mentioned. Number 4, honourable members have repeatedly warned the chairperson of CRL about misleading Parliament. CRL chairperson, and that was concerning representativity and statistical claims. I have done the math on how many Christians are represented by the Section 22 committee. I arrive at 26 million of adherents of the entities CRL declared to have co-opted. I've written a whole paper on it if you'd like to have it to pursue that matter. Finally, as a scholar, I encourage you to request evidence for claims that are made without substantiation. Another such claim is that the situation regarding spiritual abuse in South Africa has become worse since the 2015 study of CRL. You could consider asking the CRL to make transparent how many complaints pertaining to religion they have received annually since then. It's about 18 in the last reported year, and how many of those actually pertain to matters of spiritual abuse.
Your time is up. Thank you very much.
Thank you for your attention.
Please share your paper as well with the Secretariat. It should be interesting. Thank you very much. Let's take the now, Honorable Swart. You
Yes.
will not be.
Yeah, I appreciate that, Chair. I think I'm out of line now. I'll rather step back to allow organizations to give inputs. Or is it an opportunity for MPs now?
No. It's too early. MPs we've got a bit of time. We've got about 6 people in front. But let's listen to them. Yeah, no, don't worry. You just wait. What we'll do is we'll just call on MPs. Then you'll come at that time. Then we don't have to keep pushing you from the queue. Let's get it's becoming very interesting. So let's allow the following speakers: Rasim Malerwe, then Lucas Nkosi, Madeleine Ellis, Philip Rosenthal, Prof. Bill, Tembi Tulwana. That's the order. I will keep reminding you. Let's proceed. We start with Rasim Malerwe. Please proceed.
Well, you can read that.
You have a bit of a problem with your sound. Try again.
He's muted, Chair.
You muted now.
Is that better?
That's it.
Thank you very much.
Thank you.
Yeah, I represent the Council for the Protection and Promotion of Religious Rights and Freedoms, which we could say is the caretaker of the Charter of Religious Rights and Freedom.
Rosenthal, you need to mute. We can hear your conversation. Let's proceed. Please stay muted. Let's proceed, Mr. Malerwe.
Thank you. So we take care of the Charter of Religious Rights and Freedoms and the Code of Conduct. I submitted it in a letter to you, Chair, and I put it on the chat box. If there's anybody at the end who would like more information about this, I will put my email address in the chat box and people can just drop me a line. The Charter spells out the scope and content of religious freedom and came into being in 2010 through a wide consultative process. It was signed and is still supported by all major faith groups, churches, and other organizations and individuals. The Code of Conduct, in turn, is the product of a counter-proposal that was made to this committee 8 years ago, when the idea of a law to regulate religion was floated for the first time. After the COCTA hearings in 2018, I think, we drafted the code through another consultative process, and again, many religious bodies and organizations endorsed or otherwise supported the code. Where the Charter spells out the rights, the code spells out the responsibilities. So the code focuses on things like respect for human rights, especially human dignity, and to refrain from any form of abuse and anything else violating human dignity, also the rights of children. But it also includes matters about civic responsibilities, respect for the law, proper administrative procedures, sound financial practices, and so on. These documents, already so widely supported, provide for true self-regulation. The voluntary commitment to them is the way to bring change where it is needed in the religious sector. We share the concerns of the CRL Commission and deplore any abuse in the name of religion. But to make another law, well, apart from putting an almost impossible burden on the state to enforce it, too much will be lost. Most of all, the precious right to religious freedom. We are not saying don't do anything. We say the Charter and Code are the proper alternative. They are open documents available to everybody to endorse them, include them in the official documents, take ownership of them, and commit to them in their day-to-day activities and conduct. It will be a process of hard work to get people on board, but it will be worth it. So we invite everybody to take up the Charter and Code as the proper self-regulatory way forward to address malpractices in religious communities and ensure the well-being of people in those communities. I thank you, Chair.
Thank you very much. Your suggestions are fairly succinct and clear. So please, you may just share, if you haven't already, those proposals that you have, but we note your contribution. Thank you very much. Let's have Mr. Lucas Nkosi.
Thank you, Honorable Chair, for the opportunity. We managed to submit the document which is there in detail. So in the interest of time, there are, I think, 3 or 4 things that I just want to highlight. And the first thing that the chair you spoke to is the issue of legality of Section 22. Now, I have noticed that there was no careful reading of that provision in the Section 22. So CRL in its became creative with that line of that provision. Now, if you carefully read Section 22 of the CRL Act, it makes provision for 2 categories of Section 22 committees. And the number 1 is members only, meaning commissioners only. And then, or alternatively, members and staff or other people. But now, in the reading of the CRL, to create this so-called independent Section 22, they have put a comma where that, after staff, they put a comma to create a 3rd category. So where we stand as the COCC, that committee was not lawfully, appointed because it did not follow the letter of that section there. And then now a Section 22 committee is a committee of the commission, but the instruction from COCTA in that recommendation of 2018, February 14, for self-regulation, it was not something that was supposed to be done by the CRL, but the sector itself. Now, in its argument, the CRL says we had to work out something so that we have a financial backup, to assist that thing. And then that thing, there's a provision within the Act from Section 36 to 38. If the issue of funding was a problem to fund the process and so on, provision is there. And then, so that the sector owns the process itself. So we would like for the committee to relook and carefully read, that line, and then to see, and we'll take it from there. The second aspect now is the issue when you reduce all the challenges that CRL is raising and why they do what they do. They've been saying even previously that it's about curbing issues of abuse. So the issue is about abuses. Our current law speaks to what to do to the abuses that are there. And then even in the previous, from somewhere October and so on previously, there have been 4 cases of religious leaders, pastors who have been successfully prosecuted for issues of abuse. And our argument even previously has been, if the law is being applied, it works effectively. The NPA has proven with those successful prosecution of those cases. Now, if it's an issue of abuse, our law speaks to abuse. So if we set up a committee to say we are dealing with abuses, doesn't our law speak to abuse? There are acts of parliament that speak to issues of abuse and how the courts should deal with. And the third thing, as I close, has to do with, why demand, the issue of demand that is being made, that the church as a juristic person is subjected to rules that don't apply to other sectors. Like, for an example,
the time is up.
Okay, thank you.
Thank you. Thank you very much. Let's get the next speaker, Ms. Madeleine Ellis.
Good morning, Chair and honourable members, fellow colleagues. I'm here on behalf of the Full Gospel Church of God in Southern Africa, and I will refer to the FGC in this regard. The FGC makes the submission in light of the CRL Rights Commission's renewed effort towards the regulation of religion, and in particular the establishment of the so-called Section 22 Committee. The FGC considers it necessary to place on record the
Sorry, something has gone wrong there. Mr. Nkosi, please mute your mic. But let's try and see what's the problem. Madeleine, you'll come back. Try and see who can fix the problem. Let's take the next one.
Mute.
Rosenthal, Philip Rosenthal. I'm not sure whether that's Rosenthal showing there. It looks like, okay. Now you will choose who's going to speak. I see you're sharing. Please proceed, but only one of you will speak. Please go ahead. Unmute yourself. Madeline will come back as soon as she fixes her stuff. Please proceed. Bishop Begwa, is you who's speaking. Please unmute.
Thank you, Doc. Good morning to my colleagues. Good morning to the chair of the Portfolio Committee. Bishop Templeton Begwa is my name, representing the African Religious and Traditional Leaders Council, KDF, Religious Forum, Concerned Christians of Cape Town, Religious Forum Without Walls, churches, network leaders, and umbrella bodies in South Africa. We are a national body in all provinces. Well, Mr. Chair, we tried everything that we could in our powers to try to get attention from the chair of committee. Now we have decided to submit this petition to you and the speaker. We, the undersigned leaders representing Christian churches, religious formations, traditional leaders bodies, advocates network, and community structure in Cape and across South Africa, request the Parliament to investigate the conduct of the chairperson of the Cultural, Religious, and Linguistic Communities Commission, Toko Mkhwanazi Kalova, in terms of Section 17 of the CRL Rights Act of 2002. The CRL chair has made multiple public statements that warrant investigation. This includes statements that are misleading, disrespectful to religious beliefs, divisive, intimidating, and discriminatory to religious communities, and proposing extension of the CRL powers to enable the authority to prohibit just practitioners which are outside of the constitutional mandate of CRL Section 185 or any other organ of state. The codes attached annexure and thus are attempt of contravene Section 41 of the Constitution. The chairman of the Section 22 committee appointed by the CRL Professor Musakulu made multiple public allegations against the CRL chair in his public resignation letter on the 15th of January 2026 that warrant investigation on its own. This includes interference, including chairing the process of the Section 22 committee while sidelining the actual chair, that is Professor Musakulu, holding private meetings with certain members after publicly promised the independence and co-opting new committee members without consultation or clear process. The CRL chair repeatedly recklessly actions and statements are causing division, undermining the harmony and tolerance in the religious communities. That is CRL Commission mandate to protect and undermine the credibility of the CRL Rights Commission, contrary to the requirements of Section 15 of the CRL Act and Section 185 of the Constitution. This compromised credibility undermines the legitimate and mandate functioning of the Commission. We request an inquiry into the conduct of the CRL chair in terms of Section 15 of the CRL Rights Act 2002 by a committee of the National Assembly that, if an investigation she is found in contravening that a recommendation to made to the president for her removal in terms of Section 17 of CRL Act and Section 194 of the Constitution, relevant and attached. Chair, thank you so much. God bless you.
Yes, thank you very much. I will still try, and if there is more time later, we'll still open, but we've got the thrust of your submission. Now, Madeleine. Yes, proceed.
Muted now.
Madeleine, please proceed.
Thank you, Chair. Apologies for the technical issue earlier. As I've stated, the Full Gospel Church of God in Southern Africa wishes to make submission in light of the CRL Rights Commission's renewed effort towards the regulation of religion, and in particular the establishment of the Section 22 Committee. And in this regard, it places the following on record. The process followed in establishing the Section 22 Committee, the apparent objectives of the Section 22 Committee, the constitutional implications of regulatory intervention in the religious sector, and the absence of transparency and meaningful consultation. The issues raised are not merely
Sorry, Mr. Rosenthal, please mute your phone, your mic.
The issues raised are not merely administrative or procedural. They implicate fundamental constitutional principles, including freedom of religion, institutional autonomy, and the separation between church and state. The lack of transparency and selective participation in the establishment of the Section 22 Committee is concerning. Key stakeholders within the Christian sector were excluded from participation, the Full Gospel Church being one of them, a denomination that has existed in South Africa since at least 1910, and which has actively engaged with the CRL and the Parliamentary Portfolio Committee on COCTA since at least 2017, was not invited to participate in the formation of this committee. Given our historical engagement and standing within the Christian community, such exclusion cannot reasonably be regarded as incidental. It raises serious concerns regarding the fairness, representativity, and the administrative propriety of this Section 22 Committee. It appears that the Section 22 Committee has been established with a primary focus on regulating the Christian church rather than the religious sector broadly, which is also deeply concerning and raises questions regarding equal treatment, rationality, and constitutional compliance. It is common cause that the CRL has previously called for Parliament to enact legislation regulating religion, and significantly, this committee, in prior engagement, rejected those proposals for legislation aimed at regulating the religious sector. That position recognized the constitutional risk inherent in state regulation of religion and sufficiency of existing legislative mechanisms. The substantive position of the FGC is that they wish to unequivocally state that it does not deny that there are harmful and abusive practices in certain quarters of the religious sector. Such conduct is condemned in the strongest possible terms. However, the existence of isolated abuses cannot justify unconstitutional regulatory overreach. The FGC's position is grounded on the following principles: institutional religious autonomy. Religious institutions possess constitutionally protected autonomy in matters of doctrine, governance, discipline, and membership. Self-regulation within properly constituted and accountable religious bodies is not only constitutionally
Please mute. Somebody's mic is running.
Self-regulation within properly constituted and accountable religious bodies is not only constitutionally permissible, but preferable. State or quasi-state oversight of internal religious affairs risk unconstitutional intrusion into the doctrinal matters and ecclesiastical governance. Freedom of religion is protected under Section 15 of the Constitution and is intertwined with freedoms of association, expression, and dignity. Any regulatory scheme that permits state oversight of doctrine, internal discipline, leadership appointments, or ecclesiastical governance is constitutionally perilous. The FGC cannot support or recognize any structure that subordinates ecclesiastical governance to state or semi-state oversight beyond constitutional limits or imposes regulatory requirements inconsistent with religious freedom or seeks legislative endorsement without broad-based and transparent consultation. Engagement is welcome, but constitutional encroachment is not. Thank you, Honorable Chair.
Thank you very much. Thank you. We gave you a bit of injury time there. All right, thank you very much. Yes, let's go to Professor Bill.
Good day, Mr. Chair. Can you hear me?
Now I can hear you.
Thank you so much, Mr. I speak on behalf of the Doctoral Council of Churches, representing the African independent churches in our country. We have a position on two things. One, we have already a registered body within our country called the ACRP, which is the Association of Christian Religious Practitioners. It's a SACWA recognized professional body serving pastors, ministers, leaders, and counselors in South Africa and beyond. Now, the mere fact that we want to confuse issues and bring all other faith under one umbrella body, that's the problem we have in this country. We had got to have the Muslim to have their Muslim council who will represent them. We have the Christian council that will represent the Christians. And let these bodies be all professional registered bodies. We do have ACRP for the Christian religious bodies in South Africa. It was established 2014, and the ACRP promotes the professionalism of Christian ministry through formal recognition, ethical standards, and access to continued professional development. The mission of this ACRP is to support Christian religious practitioners in fulfilling their calling and promote the provision of training to religious practitioners. My advice, Chair, to all of this is for the CRL leadership to go and sit with the leadership of the ACRP and let them educate them concerning the topic of religious leaders within our country. And I think out of that discussion, the CRL leadership will learn a lot that they actually need to know about the Christian community in our country. And as much as we have some other faith, yes, they most welcome to go and establish their own professional bodies. And the problem that we have, if you want to put all these things together, there will be some sort of competition, and it will people will overstep their boundaries because they think they understand that particular fraternity and they do not understand that. So it is important that people must understand. We cannot put these things together in one basket. That's when we're going to have trouble in this country. We respect other religious leaders from all other faiths, but I think they need to have their own identity, promote their thing, and have a representative from their side onto these national structures. And I think that's the only way out for us here. Because you will have the Sangomas, the traditional leaders, and all of that. They're also part of the CRL. And they will also feel in a way that we, as the Christian leaders, become now competition to them. And then we will start another fight again. So my humble plea this morning is for us to recognize our diversity and create a platform of diversity. And let each formation have its own representative and stay under its own blanket. My Chair, that is my proposal this morning. May God bless you.
Thank you very much, Prof. Bill. Thank you very much. Let me take the last hand there is Tembi Tulwana.
Thank you very much, Chair. I also thank the members that are seated there and the religious leaders. I need to begin by indicating that I'm from Inkululeko Yesizwe Association, which was formed by Inkosi Yamakhosi Omoya, Dr. Zwilezo Radebe, and has a membership of 10 million people. Chair, we have traversed this road from the onset when the CRL started intimating the religious root of her wanting to interfere with religion and any other faith. However, it failed, and this morning I hear that the mandate that she had in trying to have a peer review, that report lapsed, so we start from the beginning. But she has other ways of doing things with this Section 22 committee of hers. I would say it is her Section 22 committee because she never consulted anybody. And my point is, as a very huge formation of people led spiritually, who practice spirituality, we were never invited. At each time, she has all these conferences and meetings. She's never invited us. The CRL know about Inkululeko Yesizwe Association, and we have attended all meetings, even the one in Parliament. I do want to indicate that her exclusion of such formations is not going to put her in any better stead if she thinks that a huge group of people like us will not ensure that their voice is heard. And this is what we're doing this morning. What I want to say is, I do concur with the first four speakers because I don't want to repeat what they had said. What we want to say is, we are not in support of the manner in which Mrs. Togoxaluva Mkhwanazi is handling a very important Chapter 9 institution that needs to lead, guide, and give advice and ensure that there is collaboration within churches and those that do untoward activities. There are good bodies within South Africa. She must refer those things to. However, we also say to her, her manipulative ways of wanting to create this Section 22 committee are not going to work, and we are not supportive of the stance that she has taken in South Africa. And we say, with immediate effect, okay, she needs to be investigated, and the process of the Section 22 committee should be started all over again, and everybody that will add any salt meaningful to South Africa and the faith groups in South Africa should be invited. Thank you.
Thank you very much. We're going to take one last hand, which is Professor Kulu. Then I'm going to open up for the members of Parliament to make their comments. I'll open one more time, but with a shorter timeline after that, so that those members who might wish to add what might have remained, clarify, or answer, they'll get that opportunity. That would be after the members of Parliament have made their comments. Professor Kulu, you're on the floor.
Good morning, Honorable Chair and the Portfolio Committee, Kabazela. My input is very short now because the members have spoken, and I agree with all of the submissions that have been made. I just wanted to say, because I was inside there, maybe I can shed some information in the sense that I saw how this committee was formed, and I saw how Mrs. Taluva directly participated in the writing of the document, which they released on the 19th of December. And what made me to leave eventually was that, although I was appointed as a chair, I never really chaired any meeting to the full. And on the 17th and 18th, when that document was drafted, she just said, no, I'm chairing now, Reverend Professor, I'm taking over. And she chaired, and she was raising her hand, and she was directing the writers that but they must write in that document and so on. And then she goes to the public and says, no, that Section 22 committee is very independent of the commission, which is not true. And as a pastor, I found it that I cannot collaborate in a situation where lies are being told to the public when we know internally that it is not so. But also, there were no criteria to get people into the Section 22 committee. It was very random. You go to this church and then you jump the church and then you go to the next one and so on, according to whether they will agree with you or not. And so I had a problem with that as well, because I think those people who are there, none of them is really trained to understand the issues at hand to the extent that there can be a productive outcome out of it. Then, of course, the next thing that I would like to share with members of the parliament is that, as has been said about the issues of theology and so on, I had said that it becomes important that the document, because it's a Christian document, it's going to be important that it must have a biblical basis, it must have a doctrinal basis, a theological basis, and issues of ecclesiological basis. All of those things are not there. It's just a thumbsuck. And people talk like it's in a taxi rank or anywhere where there's no terminologies that are used. And one of the days that made me really decide that I can't stay here was when they were laughing at the doctrine of fivefold ministry, saying there's nothing like that. The pastors are just creating this thing. It does not exist. I thought that was a direct attack on the church. And I said, I have to leave before I am associated with this direct attack on Christianity. Another issue, of course, was why are other religious institutions, communities not being taken into account? Why focus on Christianity only? And so eventually on the 19th December, because I was not participating in the writing of that document, when they went to the media, I said, no, I can't go to the media, because if the media ask me a question, I will not be able to answer the question, because I've not participated in this and I disagree with the approach. Because, for example, when there was a launch, I had terms of reference which I had been given on the 15th of April when I arrived. When there was a launch in October, on the 1st or 2nd of October, when I went on stage, I was invited to come and present those terms of reference. An official came rushing to me to say, no, don't read those terms of reference. There are new terms now that have been drafted. And those new terms were talking about regulation, establishing some kind of controlling body, and forcing Parliament or approaching Parliament for a legislation. And those are the things that cumulatively led me to deciding that I'm not going to be able to stay here. And I had warned the chairperson, Mrs. Kalova, from June, that there's a discrepancy between what I've been told and what is actually happening internally. I thank you, Mr. Chairperson.
Thank you very much, Professor Kulu, for that insight.
Sorry, Chair. I wanted to ask if I can make a written submission, because there's a lot that I had shared with the public. Maybe I can also share with members of Parliament.
Yes, certainly. You are welcome to do that.
Thank you.
Thank you. I'm going to request members now of the portfolio committees, members of Parliament, if they would like to indicate their own reflections on this matter. We'll allow Mr. Manikam to come in whilst the members are raising their hands. Please mute. Professor Kulu, please mute. Professor Kulu, please mute. Mr. Manikam, please come in, and then I will follow with Mr. Swart and other members of the committee if you'd like to comment at this point.
Thank you, Honorable Chairperson Kabazela. I just want to make two comments, and it will be very short, less than a minute. Number one, in terms of making these documents available to the public, I think if we can just attach it to one of our departments where we can access it, the ones that we've spoken about. The other thing is there's so many issues being raised against the chairperson. And I just wonder, why is there no action being taken or no intervention put in place? And then Member of Parliament had mentioned way forward. My way forward is, can we just have the 9 provincial indabas put in place that can be recorded so we know we have maximum participation from the communities, and thereafter we can pave a way forward. Thank you, Chairperson.
Thank you, Mr. Manikam. This is the first engagement we have since there have been objections to the statements of the chairperson. And so all of the issues we're beginning now to try and pull together. And so we will find a way to deal with these issues as we move on. But the complaints around the chairperson have arisen in the past few months when the communication between us was now directing the matter to be back to Parliament. Since the memorandum, I did give a bit of a background to this matter at the beginning. I'm not sure if you missed a bit of that. So we now at this point trying to deal with all of those issues. May I then ask Mr. Swart to come in? Other members of the committee, anyone would like to make a comment? Mr. Swart, please proceed.
Thank you, Chair, and thank you for allowing me the brief input. I think it's very clear from all these submissions that of the submissions today from various faiths that no one has supported the CRL's proposal. It is also very clear from your input, Chair, that the previous Portfolio Committee rejected the proposals from the CRL. And in that regard, I would recommend a motion to Parliament to revive the work of the previous Portfolio Committee. That is, I'm speaking now as a whip of Parliament, that is the normal thing that can be followed should the committee so desire. Secondly, it's very clear that there are abuses taking place. Chair, I would suggest this Portfolio Committee also meets with the Justice Portfolio Committee, where I am a member, to discuss loopholes that may exist in the criminal justice sector that were referred to, and how to enhance the implementation of existing laws. That, I think, is something to look into. I think there are, from our perspective, sufficient laws. It is the implementation of these laws. From our perspective, Chair, we do not think that the proposal of the CRL is the way to deal with abuses. We've now also heard very clearly, Chair, that since the previous Portfolio Committee, COGTA, there's been significant improvements in self-regulation. And we need to take cognizance of the Code of Conduct under the Charter, of SACOF's input, 24,000 church members. That is very significant. Churches that are now under a body, as well as the inputs from other faiths. Chair, I think it's very clear for the committee to deliberate and come out very strongly at a certain stage that it rejects any state regulation of religion under the guise of self-regulation, as this would clearly be unconstitutional. And that was the reason why it was rejected in the previous Portfolio Committee. Chair, I'm also deeply concerned about public utterances of the CRL Chair. I myself, as a Christian believer, find them highly offensive, and I do believe that it warrants an inquiry by this Portfolio Committee, and I'd strongly urge you to consider that. So, Chair, I would briefly just recommend the revival of the report of the previous Portfolio Committee through a motion to Parliament, make it clear that Parliament did not accept the CRL report in the previous Portfolio Committee, and that this Portfolio Committee will now be engaging on the work of that Portfolio Committee, plus going forward. Meet with the Justice Portfolio Committee to deal with criminal justice issues. And the Section 22, Chair, we've now heard from the chairperson of the Section 22. Serious lapses. If I was on the committee, I would ask for a full set of minutes and hold an inquiry into that issue as well. It is deeply disturbing what is happening. And may I just conclude, Chair, by quoting from a judgment of Prince versus the Law Society of Cape Town, which 2002. This is very important. The state, and that is us as Parliament including, where it is reasonably possible, should seek to avoid putting believers to a choice between their faith and respect for the law. And Chair, any move of state regulation of religion would amount to us as believers being put into conflict, possibly with the law, and that we want to avoid at all costs. Chairperson, that is the position of the ACDP at this very preliminary stage, and I thank you for the opportunity.
Thank you very much, Mr. Swart. May I invite Honorable Taibosh?
Thank you, Chair. I was largely covered by Honorable Swart, Chair, but I just, you know, it's as clear as daylight, Chair, that if you look at the amount of people, the amount of attendees today, and the amount of different church organizations and bodies and religious bodies that have attended this morning's discussion, how serious this matter is. And I can just agree, Chair, that we revived that report of the 2018 COCTA Portfolio Committee, and we need to almost revive the entire process, Chair. And we have to get the CRL in as well, because if you look at all the allegations and all the things that are going on there, it tells me there's definitely something wrong. So, you know, we can't just put a Band-Aid on this. We need to get to the root of it. And I don't think all these people are unhappy for nothing, Chair. So the Portfolio Committee's, COCTA Portfolio Committee's job is very, very clear at this point in time. Thank you, sir.
Thank you. You asked a question earlier about the different groups that interacted with the CRL, and I did say that I was going to just try and clarify that. Largely, people who are here are those who either were party to the memorandum or party to the objections to the processes. We have not invited those who were listed as having supported the process. So we will need to meet with them at some point. So I think it's important to keep a context of these submissions because the process is only just beginning. There'll be a lot more interaction as we move on. But thank you very much. Let's proceed to Honorable Mukalipi.
Thank you, Chair.
No, Chair, I'm partly covered because I wanted to check if have we engaged with all people, especially from religious community. But your response now is clearly that we still have to engage with those who are in support of the process. Therefore, we can be able to say, let us call now the commission, especially the chair, to come and clarify some of the issues that were raised here. But without meeting the other group, it won't be sufficient to call her now or to call the commission to clarify some of the issues that were raised here in order for the committee to take a decision. Thanks, Chair.
Okay, no, thank you very much. Let me also say that we did ask the CRL to attend this meeting, and they then said, working under the guidance of their legal team, they believe that the issues on the table are the same issues that are in court, and they would not be able to participate because the matter is for them in court. So, nevertheless, that does not stop the committee from interacting with the CRL. Let's take the following members, Honorable Saints van Wyk, and then we'll follow with Honorable Subrathi.
Thank you very much, Chairperson. Chair, you did indicate at the beginning of the meeting that we will continue to engage with our spiritual leaders regarding all their concerns and so on. What I will also like to bring under your attention is that there is also spiritual leaders in Gauteng province who would also like to engage on these matters that was raised here. So I would just like to bring that under your attention and ask that they must also write their letters so they can be part and parcel of the next engagement. Then also, Chair, I must also communicate my concern when I hear about all the concerns and matters and issues that was raised against the chairperson of the CRL Commission. It's very evident that, I mean, even utterances when it comes to spirituality and pastors, it is honestly an outrage. It is very much offending. Myself also as a Christian, I also take offense to it. But unfortunately, as a MP, maybe I have to be neutral about it. But the fact of the matter is, we can't not let it go unseen, Chairperson. So I just wanted to raise it, Chair. Thank you so much.
Thank you, Honorable Saint. You have advised the religious leaders in Gauteng appropriately. They'll send us a notice of a request to meet with the committee, and then we'll process it from there so we know who we're calling. So let's proceed. Honorable Subrathi. For the members, religious leaders who are here, I will give 1 minute each for those who might have something that fell off or want to react to anything, so that before we round up, you would have been given a bit of a space to contextualize anything that you think might need attention. So I will come back to you for 1 minute each, and we'll be strict 1 minute. Imran Subrathi.
Thank you, Chairperson. Thank you, Chairperson. Chairperson, let me begin by appreciating, firstly, you as the chair of this committee in really convening this meeting. As I had indicated when I introduced my joining the meeting, I received several calls from religious leaders and groups and coalition that representing almost in excess of 20 million faith-based followers, indicating to me that, Honorable MP, this is clearly an overstepping of the responsibilities of government to regulate religion. And I think I must appreciate this opportunity that you've given in a democratic parliament for their concerns to be ventilated. And I think that brings significant amount of relief to them that they have expressed. And of course, with that, a significant amount of hope that this portfolio committee, COCTA, or having heard them, will also hear the other side of the story, because we are a democracy, and then accordingly take a decision to move forward. Chairperson, I think there is a clarion call that we must be cautious not to overstep our mark. I think there's also a need for religious communities to understand that there needs to be some form of internal regulation between themselves to guard against the concerns that governments may have. And I think we must trust religious bodies across the board, across all faiths, that they are organized, and perhaps they need to get more organized and maybe provide to this committee some form of evidence that there is that self-regulation. But clearly what we're hearing in this engagement today is that there is a line, and the line must not be overstepped. Let
we are hearing, let religious leaders, let religious communities self-regulate and manage. And if there is a need, then we must utilize the criminal law and the civil law to bring to book those who transgress religious borders and those who use religious for their own personal reason. Thank you so much, Chairperson, for this opportunity, for convening this meeting and allowing us and the religious community an opportunity to engage. Thank you so much.
You're welcome, Honorable Member. I have now a few hands. We are strictly 1 minute, and I will go up to 5 members. I see we've got 3 now. I've got space for 2 more. So let's start. Okay, I see 4. Then let's start. Lucas Ngosi, if we can take you in, and then we'll take the next. Is Bishop Mzamo, then Pastor Theo, Bishop Begwa, and Malerwe. Is it your face or is your request for? Oh, I see that. Yeah, there's a way to raise the hand so you don't get to fall off. Dr. Kuto, I've noticed yours. Bishop Dube, I've noticed. So let's just try and follow that kind of order. All right, please go ahead. Go ahead, Ngosi.
Thank you once more, Chair, for the indulgence. Yeah, the other thing that fell off was a third point I wanted to raise, that, the church is a juristic person, as an organization, and on the principle of equality before the law. And then even laws that pertain to juristic persons, that now there's an expectations, to say why regulate everybody and not the church and so on. But there are bodies, and then therefore, if like your qualifications and so on, but now other people, like people in business, are we saying you need business qualifications to start a business? Are we saying, do you need political science to start a party? And all these other juristic persons that we are not subjecting to this. I don't remember having a peer review for political parties, where you have a body of all political parties, then subjecting them to a peer review. I don't, things like that. And that we also need to consider, to say we can't treat the church as an organization different to other organizations and so on. So on the principle of fairness, if we demand something from the church, it must cut across. Then it will mean, even with starting political parties, we need political science qualification minimum for people to start. Even those who practice politics, we need political science qualifications, as well as business and all these other practices, if we are to go with that notion. I appreciate. Thank you.
You have a bit of a problem with your system there. So let me jump you and get to the next one. Pastor Theo.
Greetings, Chairperson. Thank you for this minute. I would like from my side that, based on the presentation that has been presented by these different leaders, I would like a swift response from a portfolio committee. I thank you.
You're welcome. Thank you very much. Let's have Bishop Begwa. You are muted.
Okay. How about now?
Yeah, you're fine now. Please proceed.
Thank you, Chair. Our last submission will be that the chair of the CRL Commission failed to call a national consultative conference, which now as we are talking to you, we will wish that if that happens, we would need an independent and neutral body. It's either you as the chair of the committee or the department itself. Because if she calls that by herself, definitely myself, I won't be invited in that meeting. So we would love everybody concerned to be invited. So I propose that an independent member that will preside over that national conference consultative meeting be neutral. I thank you, Chair.
Thank you very much. Let's have Bishop Dube.
Are you able to be addressed?
Is Bishop Dube, is your hand up?
Yes, Chair, my hand is up. Thank you very much, Chair. Yeah, thank you very much, Chair Kabazela, for affording us an opportunity. There is all one thing I just want to raise, or two things. It is very clear that we, as a church, generally, we have a great responsibility, as the Word of God says, to pray for our leaders and pray for our country. But what is happening today is contradictory to this, because as I speak now in Durban, I read that tomorrow there is going to be a march of churches. Thousands and thousands of them will be marching against the government of the day. In Johannesburg, there was a march. The communities of South Africa, who are supposed to be stakeholders with the government, who are supposed to be assisting government, praying for the welfare of the country, and the religious leaders are very, very angry about the CRL. I would really commend Honorable Chair to
Cut off. Bishop Dube, you got cut off.
Particularly the last thing, particularly the last.
Cut off. So we missed part of what you're saying. If you want to rewind for a short while. Bishop Dube will have to come back again. Let's have Dr. Kotu.
Thank you, Chair. My other recommendation is going forward. Cooperative should do a research of court decisions already taken, including by the Constitutional Court, on this matter. There have been a lot of court rulings that make present-day interventions obsolete. For an example, the Constitutional Court has already ruled that however bizarre, however unconventional or strange any belief system is, practices, if there's nothing harmful, nothing unlawful, and nothing illegal happening, we should let people do what they want to do if it connects them to God. And in particular, the Constitutional Court ruling said, if someone eating grass in church thinks it connects them to God, how are they different from someone who eats bread and says the body of Jesus? Now, if the Apex Court has already made such a ruling, why is Mr. Luba pursuing the rhetoric of people eating grasses in church? So there are very key court rulings, High Court and Constitution, which should be taken into consideration in this discourse, lest we find ourselves trying to reinvent the wheel. That's my additional recommendation. Let the research be done. We have people like Forza, we have people like Professor Malebe, who have access to the legal fraternity. Let them submit all those court rulings that impact on our discussion, so that we are guided in that process. And lastly, there is conflict between how the CRL Rights Commission understands what the Section 22 committee is supposed to be doing and how the religious sector perceives it. And it's really important at this stage, instead of forcing those road shows, Professor Kubi has left, CBC is making some declarations against their own committee. I think it's fair at this stage that the activities of the Section 22 be suspended if it is necessary. It shall continue after Parliament has made a determination on this. Thank you, Mr. Chair.
Thank you very much. Let's take the next hand. I have a bit of a challenge there. I don't have a name of the person, so I'd like to get the name of the person before we can open up. I see Galaxy S25 Ultra. Can you get a name so that we can get a proper sense as to who is there? So in the meantime, let's get Bishop Makubo. You're muted, Bishop Makubo. You're still muted.
I'm still muted.
But you're okay now.
I'm okay now. Thank you very much. I really appreciate. If I had an opportunity at first, I should have stated who we are. We are Royal Covering Institute of Ordinancy. Basically, we are focused on the ordinations of pastors, Christian ethics, leadership, and unity and prayer of the Christian body. I want to also add and concur to what our brothers and sisters have just said in regarding to the issue of the Section 22. My recommendation on that matter is that the Section 22, if need be, we restart the committee, because at the point where we are, we can actually see that there is no agreement, and we totally don't agree with them, but they themselves, I think they've seen that whatever they are trying to format or do in terms of Christianity, it's not coming together. So my recommendation is that the committee be restarted altogether. And also, I will close by saying we are requesting that maybe such meeting be put in certain notifications, because not all leaders, church leaders, know about such meetings. So maybe if there will be another way of making meetings like these ones be publicly known, I think I'm trying right there to bring my suggestion. I thank you. Thank you, Chairperson.
Thank you very much. We have Pastor Mukuba. It does look like this one was Makubo, this one is Mukuba. So let's have Pastor Mukuba coming in. Then Honorable Mkalipi will let Bishop Mzamo come in first, then we can come to you, then we'll be closing after that. Pastor Mukuba.
Thank you very much, Chairperson. Just a short one here. When we are talking about a report that is lapsed, the CRL report, which was not really adopted, it raises another important question here regarding the listing of the church as the charismatic church as a domestic threat in the national security report. It's really worrying that it is stated as such that it is based on the CRL report. So I just felt that I should also raise this. That is very concerning. Thank you.
All right, thank you very much, Pastor Mukuba. Bishop Mzamo.
Thank you very much, Chair. I am Bishop Mzamo of CLUST, which is Christian Leadership Alliance for Social Development. I think importantly on my side, there is a word that I would like to really say both to the COCTA and to the CRL. One is that you cannot do anything without the people involved. Doing what CRL is doing without us, the church, broadly involved, is actually constitute that we are actually taking decisions on behalf of the church. And with the constitution, or rather the putting together of the Section 22, which was not necessarily supported by the church, really it leaves a bad taste in our mouth. Secondly, that I would actually like to request directly from you, Mr. Chair. It is a sense of protection from the CRL chair, where every word that she finds to be able to say on social media against the church, painting the church as this black horse, it should actually be stopped with immediate effect, because now the church has been painted as if it's a place where people are being abused, are being solicited, that their money has been taken away. So I would like to leave that with you, Mr. Chair, but thank you so much for this opportunity of being able to stand and share our views. Thank you.
Thank you very much. You're welcome, Bishop Nzamo. Professor Malerwe, are you on? Or is just your video that's on? Did you want to raise something? I'm just not sure you had a...
No, thank you. I'll put off my audio and my...
No. I'm not... No. Put your video back. I'm not objecting. I'm not objecting. You're probably one of the few who are keeping your videos on, and it does help to have a meeting where everyone does look alive, you know. Sometimes you look, everything is like so frozen, you're not sure whether you still have a meeting or you are on your own. So you're
Chair,
welcome.
I teach a lot online, and I always urge the students, please show me your face.
I have the same problem. Now, every now and again, I always request biometric confirmation of the presence of the member, either their voice or their face, you know, like the banks do these days. So it's not an objection. It was really more just to check that we don't leave you behind. Sometimes you have a problem with the lifting of the hand, so that was the issue. Honorable Mkhalipi, you are the last person to comment, and we're closing. Oh, we're closing at this point. Now, let's not, once I've said we're closing, let's not have new hands coming afterthought, kind of. Now, let me hold Mkhalipi and then I see Tamaha. After that, I will not take any hand. Let's if you can just hold on, Honorable Mkhalipi.
Oh, all right.
From Tamaha, please come in, and then we'll come back to Mkhalipi. Oh, he's got a change of heart, change of mind. That's fine. Then let's proceed to Mkhalipi.
Okay, Chair. No, thanks very much, Chair. I think you have handled this meeting very well. But the only gap that I need also to assist with, Chair, I have not heard for many people who have done the presentation here to take us through about their understanding about how this Section 22 was constituted. I think it's one or two who said there was no proper consultation, there was no invitation, but we love to have that information. In fact, as a committee, to know how is their understanding as they are rejecting it. In order for us, when we interact with the CRL Commission, we have a full understanding of what is their understanding. But I think also, Chair, it's also going to help if I think it's Babu Tolu, who was once the chair of the Section 22 committee, and he resigned. Also, just to send us a kind of a just short report as a committee, in order for us, when we interact with the commission, we also have this kind of understanding. Thanks, Chair.
Thank you very much. Well, honorable members and religious leaders, we have come to the conclusion of our meeting. Let me then say, I'm going to deal with the issue raised, Honorable Mkhalipi, just now. Firstly, let me thank you for having the time to come and share your views with us. We do respect the fact that you had your views, you raised a memorandum, and you wanted to express your views to Parliament. As I received the memorandum on behalf of the Speaker, we are therefore assigned by Parliament to process the matter and then come back to the Speaker with regard to how far we think this matter needs to be handled. So we take this engagement as a very serious engagement, And we want to apologize to those of you who have been calling and sending messages and writing who felt that it was taking too long. I want to say that if that was the reason why some of the churches might be marching, we do want to indicate firstly that we do take your concerns seriously. This matter is not being swept under the carpet. We are addressing the matter. It might have taken a bit of time, but there were reasons why, as I explained at the beginning, why it took that much time. But as people are going to be marching, we want you to understand that Parliament is very, very seriously interested in hearing your views and addressing the matters. And so the march should not be on the basis that you have been ignored, because that is not the case. The Speaker of Parliament gave a clear instruction that this matter needs to be given our utmost attention, and the committee has agreed to that. But between the last March and the memorandum and today, a lot of work had been done in between. As I indicated, a number of meetings were held, and also we've actually had to look for legal opinion just to clarify who stands on which side of the law insofar as your court application is concerned. So if there's any message, they should go to those who will be marching. The message should be, we actually are attending to the matter, and we do want people to know we're taking your concerns seriously. Now, the issue raised by Honorable Mkhalipi, there are a number of submissions that have been made in relation to the objection to the Section 22 process, how the CRL went about it, and how it is constituted, and what the terms of references are. So we're going to ask our team to pick those up and itemize them nicely for the committee so that the committee can appreciate. But I do note that amongst the objections, firstly was the fact that the process did not involve a large number of church bodies, and the feeling was that the numbers that the CRL claimed to have been represented in their approach is being challenged, and that in fact the numbers of bodies who feel they have not been invited have expressed themselves here. So there are many who felt they were excluded from the point of view of the organizations that were consulted and those that were left out. The second issue relates to the fact that there are those who feel it's a religious bodies issue. It's not just a Christian issue, so there should have been inclusivity. And some of those who come from Islamic faith have raised that issue, even though there was one person who felt that maybe in terms of the approach, there should be separate representation. We just leave it at that. But the point is that that was the second reason why there were objections about it. The third objection related to the fact that the purpose for which the Section 22 committee was being set up may not have been necessary, considering the fact that everyone is agreed that the transgressions need to be acted upon and be reported in the criminal justice system, but at the same time that the additional issue that was coming in was state regulating the church, to which they were objecting. So those were the issues that related to the objections on how this whole Section 22 committee was formed. One person raised an issue of the interpretation of the Section 22, actually, whether the CRL has interpreted it properly or not. And that, again, it's a matter that needs to be looked at. Now, there are various concerns that have been raised here. I think let's start from where there seems to be a general agreement. One, the agreement is that there are instances of illegal acts and transgression that do take place in the religious bodies or in the churches, which are not acceptable to everybody. Issues of physical, emotional abuse, financial abuse, issues which can actually be classified as breaking the law. Now that everyone agrees that those are unacceptable, the question of whether the number is increasing and is very high in comparison to the number of church structures or religious bodies, it's a I would say it's a moot question. But the issue is everyone agrees that there are those instances that have been reported that need to be dealt with. Now, the next issue is there are laws that should be applied, which must therefore be used to deal with those transgressions, irrespective of whether people are doing it from a religious platform or not. And that it's got nothing to do with religion, it's got more to do with the transgression of that individual. So there's an agreement there that action needs to be taken. In other words, no one condones that there should be protection of people who are involved in criminal activities. Now, the question at the end is how do you deal with that beyond the law? The question that some of the members are saying, there are proposals that they've tabled that relate to some code of conduct where various bodies would then be overseeing some of the ethical activities, the ethical conduct of members of various congregations or religious bodies. Those have been submitted, and we've said we will have to look into those submissions as such. So again, there is not a lot of objections to a process that is being managed by the religious bodies that is to look at how to guide each one's conduct in relation to what is said to be a code of conduct which is not based on a legislation where the state has to regulate the church, as it were. So there is that general feeling. Then the core of the objection becomes, apart from the selection of the Section 22 committee, is the mandate of that committee. Now, if you take it in the views of Professor Kulu, they seem to have been shifting, which means, therefore, whatever might have been understood to be the terms of reference may not necessarily be the same, because at some point they were actually changing. But the issue is whether the terms of reference of a Section 22 committee could actually be accepted when they appear to suggest a creation of a legislation by which the state would be regulating the church. That's really where the objection is coming. And in particular, this is seen as being unconstitutional from the perspective of a constitution guaranteeing the rights to freedom of association and practice of religion or religious beliefs, and therefore not something that should fall within the ambit of a new legislation that can actually be seen as unconstitutional. So the question of the constitutionality of the mandate and the objectives of the Section 22 is what is at the core of the objection. Now, when I started, I indicated that seeing that that is the point of contention, it may not be within the scope of the committee necessarily to deal with that question, because I think one member here who raised it, and I'm not going to mistaken the name at this point, but the issue was, it's a legalistic issue. It's not a religious matter. It's a matter of can you, in law, is this legal in law? Can it be constitutional? And therefore, that matter may not be within the immediate jurisdiction of a committee, but as we're looking through, we're trying to separate the issues up. So having said all of that, it is clear therefore for us that we're starting the process. We're going to hear other church leaders to understand where they stand. Now, from the point of view of the purpose of this committee is to first see whether there is adequate areas of common understanding across the different religious bodies on what can be done where we all agree to deal with the problems of abuse or misconduct in a manner that is solely left within the understanding of what the religious bodies would be able to manage as one issue. Then the second question, which is already now out of our hands because it's in court, would be a question of whether the Section 22 committee process is actually an unconstitutional mandate that we are conferring to the committee. In which case, if there is no agreement on that issue, that means the matter will ultimately get to be resolved in court. I will therefore be welcoming the other court rulings on the matter, and I think it was Professor Shimi who raised the issue of various court rulings that could also guide with regards to this matter. So we then have to decide whether in the process there is somewhere where the religious leaders can agree on certain things, and therefore we are left only with the matter that is in court, or whether in fact even that matter that is in court can proceed. The question, and of course it's not going to be a committee that decides whether the matter in court proceeds or not. It would be a matter of whether the processes we are going through, does it impact on the need for the court ruling to be done. We can still agree and still feel that the court nevertheless still needs to rule on the matter. So that's not where I'm focusing. I'm just focusing on what we're going to be trying to do as a committee. Now, two other issues that have been raised. The one issue relates to the suspension of the Section 22 committee process, that committee needs to be suspended. We note that we're not going to make a comment on it because obviously we have to research as to what that means as a committee, but we've heard that. The second issue relates to the utterances of the chairperson of the committee, Ms. Togo Mkhwanazi-Xaluva. Again, it's not the committee that would be dealing with the issue of the suspension. We just need to explore all the issues that are being raised about it so that we'll have to make a recommendation at a certain point. At this point where we are, we're not in a position to comment on it. We will have to look into that matter. So that for me brings us to a sense of these are the issues that we're dealing with. This is not the last meeting. We're going to meet other groups. We will meet with the CRL. And then I think at a certain point we will come together and share on what this committee has been able to distill out of this whole engagement. And then we will be able to see from here, where are we going, how far can we, what can we do going forward. But I think of the issues that we have raised, the first issue that for us is important is the issue of abuses that are taking place that we're all concerned with, and we need to find a way, a solution to deal with them. The second issue is to look at the question of the approach to the legislation to deal with these issues. Honorable member said we need to bring other committees in, and again I would agree that we at some point need to meet with the other committees on justice on that. So that issue of transgression, that is the protection of congregants and South Africans in general, that they should not be abused. Then the next issue is the constitutional right to freedom of exercising of our faith and religion, which is protected, and this committee will guarantee you that that protection we believe needs to be ensured, and therefore that as a principle, when we move on, we must know that we are together on that principle. Then the next issue is the issue of the conduct or PM review mechanism or code of conduct that has been proposed. We need to look at that and see how we deal with that. Then the next issue would relate to the constitutionality of the committee, its mandate and its objectives, and the possible legislation. That matter is the one that is in court, but is another matter that we are also going to be discussing amongst ourselves in this process. And the last one then relates to the question of the conduct of the chairperson and the statements that have been made. That, again, we will look into, and then we will then, at the end, conclude on all of these issues. So those, for me, are the basket of issues that we are dealing with here. Having said so, you will allow us space, honorable leadership, that we meet with the other church leaders and separate issues out, and then after that we'll obviously meet with the commission, we'll also meet with the minister. We might probably have to end up meeting with the president at a certain point, depending on how the matter has to be processed, and then we'll take the process forward. It is inevitable that we're going to have to, we are now already taking forward the issue that was lapsed, that had lapsed at the end of the last administration. So we basically have to take it forward. When we get back to Parliament, it will not necessarily be the same as it was submitted last time. It will have in it the facts and factors that have now been brought into this process as we are. Then that process will have to go to Parliament. The Speaker will be expecting us to come with this report. And so this, for me, takes us forward in terms of how we're going to take deal with this issue. But for your constituency, your congregants, please do assure them that your approaching Parliament was the right decision to take. Parliament is your platform where you express your concerns, your views, your input on issues that relate to constitutional rights that you have and are protected by the Constitution. And those rights, particularly freedom of practicing your religious beliefs, is guaranteed. We want to assure you that we will not deviate from that principle. We will also not deviate from the principle of ensuring that congregants are also protected to freely exercise their rights of freedom of religion, and that we will obviously be looking at ways of how to make sure that any abuses are kept out of the religious platforms, that people are free to safely practice their religious beliefs. So having said so, I'd like to bring this meeting to a closure and thank you all for your participation. Once we've got all these matters properly reported as a matter of minutes, we will share that with you so that you have a sense of where we were. But the process doesn't end here. There will be another meeting, several meetings, and then hopefully we'll be able to come back at the end to say, these are the issues that we have, these are the groups that we have met, these are the issues that we are agreeing on, these are the issues that are outstanding, this is the way forward, and then we can see whether we can find a way that helps all of us together to move forward. Thank you very much. With all of that, our meeting, therefore, is adjourned.